Walsh, Mr. Gaffney, your attorneys have said that you're ready for trial and that you want a bench trial. Is that correct, Mr. March?
Yes, Your Honor.
There you are. Is that correct, Mr. Walsh?
Yes, Your Honor.
And is that correct, Mr. Gaffney?
Yes,
All right. You have the right to a bench trial and you have the right to a jury trial. If you take a bench trial, I would determine your guilt or innocence and you would give up your right to a jury trial. Do you understand that, Mr. March?
Yes.
Do you understand that, Mr. Walsh?
Yes.
Do you understand that, Mr. Gaffney? All right. A jury would be composed of 12 citizens selected by you, your attorney, and the state's attorney. Those 12 citizens would sit in the jury box that's sitting right behind you. They would listen to the evidence presented, and they would determine whether the state has proved you guilty beyond a reasonable doubt. And their decision on your guilt must be unanimous. That means that all 12 jurors must vote you guilty before you could be found guilty. Do you understand what a jury trial is, Mr. March?
Yes.
Do you understand, Mr. Walsh?
Yes.
Do you understand, Mr. Gaffney?
Yes.
Okay. Your attorney has presented me with a document entitled Jury Waiver. Is this your signature on your document, Mr. March?
Yes, it is.
Is this your signature on your document, Mr. Walsh?
Yes.
And is this your signature on your document, Mr. Gaffney?
Yes.
Did you read it or was it explained to you before you signed it, Mr. March?
Both, Your Honor.
Mr. Walsh?
Both, Your Honor.
Mr. Gaffney? Do you understand that by signing this document that you have given up your right to a jury trial, Mr. March?
Yes.
Mr. Walsh?
Yes.
Mr. Gaffney? Do you understand that by signing this form that I am going to determine your guilt or innocence? That is, I will decide whether the state has met its burden of proving you guilty beyond a reasonable doubt. Mr. March?
Yes.
Mr. Walsh?
Yes.
Mr. Gaffney? Is that what you wish to do, Mr. March?
Yes.
Mr. Walsh?
Yes.
Mr. Gaffney?
Yes.
Are you freely and voluntarily giving up your right to a jury trial, Mr. March?
Yes.
Mr. Walsh?
Yes.
Mr. Gaffney? Have any threats, force, or promises been directed toward you in order to make you give up your right to a jury trial, Mr. March?
No.
Mr. Walsh?
No.
Mr. Gaffney? Do you have any questions about your right to a trial by a jury, Mr. March?
No.
Mr. Walsh?
No.
Mr. Gaffney? The court finds that all three defendants understand what a jury trial is and that they are freely and voluntarily giving up their rights to a jury trial. So next, I received a couple of things yesterday. I received a motion to quash subpoenas to Jamie Calvin and Craig Futterman and a motion of the Reporters Committee for Freedom of the Press and 19 media organizations for leave to file an amicus brief. I think, Mr. McKay, this is, who's here on behalf of the Reporters Committee? Mr. Healy?
Your Honor.
Can you put your name on the record?
Yes, Your Honor. Brendan Healy, Healey, on behalf of the Reporters Committee for Freedom of the Press.
Okay,
And Matt Topic, TOPIC, for Mr. Calvin and Mr. Fudd.
okay. Mr. McKay, I think you issued the subpoena?
I did.
Okay, and do you wish to be heard?
Yes.
Okay,
Judge, the state has indicated on their witness list that they may call Jose Torres and his son Xavier Torres. If that's still the case, then my subpoenas for Mr. Calvin and Mr. Futterman should compel them to come into this courtroom and testify. If the state withdraws Mr. Torres and his son Xavier from testifying, this point is moot. Mr. Calvin, Mr. Futterman can go. I'll withdraw my subpoenas. So I think at first glance, we need to ask the state if she still intends to call either Jose Torres or his son Xavier or both of them.
Yes, Judge.
okay.
Which ones?
Right now, both are under subpoena.
Okay,
All right. With that said, thank you. As I have indicated in at least 2 emails to Mr. Topic, who works for Lovey and Lovey and claims to be moving to quash the subpoena for both Mr. Calvin and Mr. Futterman, I have no intention of asking Mr. Calvin to reveal his source or sources at IPRA who provided him the Torres's address and names. I have no intention of going into that at all. So regarding any reporter's privilege, not necessary in this case. I'm telling you as an officer of the court that I'm not going to be asking Mr. Calvin who his source or sources were at Rupp. I don't care, frankly. I really don't. In addition to that, Judge, it's probably premature to rule on whether their subpoenas should be quashed or not, because if the state does call these two men, we'll have to see on my cross whether or not it opens up the need to call Mr. Calvin for things other than his source and Mr. Futterman. It just depends on what these witnesses say on cross-examination. I know what they're locked into. So I issued subpoenas in the event that there may be possible impeachment, or there's other areas that Mr. Torres and or Mr. Xavier Torres bring up on my cross-examination. So I would ask, I would say there's no need to rule on the motion to quash subpoena at this point. Let's see what the Torres say and revisit this issue at that time. Lastly, whether Mr. Calvin or not is a real reporter, I don't know. I don't care. I'm not asking for a source. Mr. Futterman is not a reporter. So there's no reporter's privilege extended to Mr. Futterman. He is an attorney, but he doesn't fall under the special witness doctrine precluding him from testifying. He doesn't represent the Torreses, okay? So there's no attorney-client privilege that he can rely on to convince you to bar his testimony.
But
As it may, we can move.
Mr. McKay, you asked me to not to hold the ruling or hold the argument until later, but then you started to argue
I
it.
want
So,
these gentlemen to know where I'm coming from, that's all.
okay,
Your Honor, I think.
can you just put your name on the record
Sure,
again?
it's Matt Topic.
Thank you.
PIC for Mr. Calvin and for Mr.
Okay,
I think the first issue is Mr. McKay is just fundamentally misunderstanding what the term source means in the reporter's privilege act. It's not limited to the name of a confidential source or the name of the person who provides information. It also includes quotes, means from or through which news or information was obtained. Means has been defined as useful or helpful to the desired end. This is the Slogan case decided to use.
right, which I read. And the thing is, they're saying right now that we don't need to rule on this because they may or may not need to call these people as witnesses. So it's a little bit premature. So I would rather just wait to see if they're going to call them. And if so, I can either hold a hearing if a hearing is necessary or hear argument at that time.
I think that's fine. It's no problem. There would need to be a written application to divest.
Oh, I read it.
And there would need to be a written application to address the special witness doctrine. I can represent to you that Mr. Futterman has had no discussions with the Torreses and can provide no useful testimony at all. So I think that sort of takes that out of play in the question of whether Mr. Futterman, as working with a reporter, falls within privilege, which is certainly our position. So that just leaves that does leave Mr. Calvin. If that's like you receive, that's fine. There needs to be a written application filed that lays out what the statute requires and what the fellatio case talks about in the context of the special witness doctrine, and we can certainly respond to that. But that needs to be done in writing, statute.
I'll put it in writing as soon as we hear from the Torreses.
Okay. So I think it's premature at this point based on what Mr. McKay is saying, because he's not sure if he's going to even need to call them as a witness or wants to call them as a witness until he hears what the testimony is from these two people. So I'm going to withhold any arguments on that, withhold any hearing on that, and we'll just pass that motion for now. Yes, Mr. Healy.
With regard to the proposed amici, my task is relatively simple, which is just to see if we can actually go up here and then have our brief team file. Can we do that at this juncture?
No, I'm going to hold off on everything at this point because it might be a little bit premature.
Fair enough.
Okay. Ms. Brown Holmes, is the state proceeding on all counts?
Yes, we are.
Okay. Are there any motions to exclude witnesses?
I make a motion to exclude witnesses.
We would join them.
Okay. And where's Mr. Fahey?
Judge, Thomas Gaffney also joins in.
Okay. Motion to exclude witnesses is granted. Yes, sir.
Does that apply to Mr. Calvin, who's here as a conventional journalist?
Yes.
Yes, thank you, Judge.
Then I would ask that we try to get this resolved now.
And I said no. I said I'm going to hold it. Okay.
So he's ordered to leave.
Yes. There's a motion to exclude witnesses.
When would you like us back? Do I need to just?
I don't know
Date of the subpoena,
That's a
or-
good, that makes a good point, Judge.
One second. Only one person can talk at a time because the court reporter can only take down one person at a time. So my suggestion is, I don't know what order the state is going to call their witnesses. So I'm not going to address this until after these witnesses have testified. I'm not sure, and I'm not even gonna ask the state what order. They can call their witnesses in any order that they choose. So it would be after that,
Okay, can we just be notified then of when we need to come in?
of course. When did you subpoena them for?
Thank you. Thursday, the 29th. Now,
But you'll know, you
that
might
was when
know.
we were starting on Monday.
Right.
So, I will be in contact with counsel, but the subpoenas were for this Thursday. Your Honor, I may be asking you to order witnesses who do show up Thursday to come back on.
Of course,
Thank you.
of course. When we'll have to decide what dates we're gonna, I know it's going into next week for sure now. Not Friday, just a housekeeping matter. The parties did contact me on Friday and asked me to hold the case, and I put it on the record yesterday, asked me to hold the case from yesterday until today. What I didn't put on the record yesterday was, all of us were under the understanding, I know certain attorneys were not available this Friday or Monday. So court's only gonna meet this week, Tuesday, Wednesday, Thursday, and then we need to pick what days after that. Is that a fair statement,
Yes, Judge.
Ms. Brown Holmes, Mr. McKay?
Yes.
And Mr. Pugh or Mr. Breen, fair statement?
Yes, sir.
And Mr. Fahey,
Yes, Judge.
regarding the scheduling?
Yes.
Okay, so are there any other issues before we start with opening statements?
Yes, Judge, there's one issue that we would like to take up with the court in chambers, but on the record.
On the record in camera?
In camera.
Okay, so we're gonna be in a short recess. I'm gonna direct the court reporter to come back in chambers and we will do this in-camera hearing.
Judge, I also be there. I'd like to discuss briefly a schedule.
I assumed everybody was,
Yeah, no, we're not.
all defendants, all
I was the only-
attorneys, except for the press,
Okay.
okay? All the parties come back.
remain seated and quiet.
Okay. Okay, the record should reflect that all three defendants are present, all of their attorneys are present, all of the special prosecutors are present. Ready for opening statement? Ms. Brown Holmes?
Judge,
Mr. Calvin is still.
Your Honor, may I be heard on this issue?
What else is there to hear?
Well, Mr. Calvin is a reporter who's covering this trial. He's being excluded from the entirety of the trial. We've had no.
No, that's inaccurate. He's not excluded for the entirety of the
When is he
trial.
excluded?
And I made myself perfectly clear, I believe, that he's excluded until we address the issue of the motion to quash the subpoena. And it'll be after the state's witnesses that Mr. McKay mentioned, the Torres, I can't remember the name, Torres is.
Well, he's here as a reporter to cover this trial. And that order excludes him then from doing.
Correct.
The First Amendment right to do that. We understand if you want to exclude him while the Torres is testifying, but other than that, I don't see any justification for keeping him out of the trial when he is only going to be here, if at all, on an extremely narrow issue that can be narrowly tailored. And no, excluding him entirely is excluding a member of the media from covering a public trial with no justification that I have seen as to why he needs to be excluded other than for that very limited time.
Anything further?
No.
Your objections noted but overruled. State?
Judge, because this is a bench trial, we have elected to keep our opening statement brief.
You can keep it whatever length you choose.
This case is about violating the public trust. The case is clear. The case is straightforward and it's concise. It boils down to what defendants wrote on paper versus what is shown on video. The evidence will show that defendant March, defendant Gaffney, and defendant Walsh each knowingly filed false police reports, thereby committing the act of official misconduct and obstruction of justice, and that they participated in a conspiracy to commit those same crimes. So what did they do? The evidence will show that on October 20th, 2014, defendant Gaffney and his partner, Officer Joseph McGilligan, were on duty in the 8th District. They received a call through dispatch that indicated that there was a man holding a citizen, a male who he caught breaking into trucks and stealing radios, and that this was occurring near 41st and Kildare. Defendant Gaffney was driving the squad car at the time, and so they drove over to that location. When they got there, there was a man who said to them that the person they were looking for had walked off toward 40th Street. So defendant Gaffney and Officer McGilligan drove that short distance and quickly encountered a young man who was walking toward Keeler. The young man actually tried to hide in the bushes, but they saw him. And so Officer McGilligan, who was the passenger in the car, got out of the car, walked over to the young man and said, "Hey, turn around, show me your hands." The young man, who we now know is Laquan McDonald, was a 17-year-old African-American teenager who was wearing a hoodie and some jeans and had kept both of his hands in his pockets. And then he took his right hand out of his pocket and showed Officer McGilligan the knife. Officer McGilligan then said to his partner, defendant Gaffney, "He's got a knife." Officer McGilligan then drew his gun. Defendant Gaffney then called police dispatch and reported that there was this offender who was walking away from them who had a knife. Police dispatch then requested a vehicle with a taser to head over to that scene. McDonald, however, ignored Officer McGilligan as McGilligan continued to say to him, "Drop the knife, show me your hands, stay still, come here." McDonald continued to walk away. McGilligan continued to walk behind him. He stayed between 10 and 15 feet behind McDonald, which he thought was a safe distance. Defendant Gaffney continued to drive the car alongside as they walked. As McDonald got to the intersection near Karloff, which was approaching Pulaski, defendant Gaffney veered his car in front of McDonald in order to stop him from moving east. McDonald stumbles and he pops the tire with his knife. Defendant Gaffney could still hear the air hissing from the tire, but the car was still moving. So he continued and again moved the car in front of McDonald, attempting to stop him from moving east. McDonald then scratches the window of the car with his knife, but he then continues to go in his direction and to ignore Officer McElligott and Defendant Gaffney. Officer McElligott then puts his gun back into his holster and he starts to chase after McDonald. McDonald then goes through a parking lot near a Burger King that was nearby. At this stage, Defendant Gaffney and Officer McElligott are engaging in what could be called good police work. They're following the potential subject. They're trying to engage him. They're keeping a safe distance. They're using time. They're waiting for the taser. They're assessing and reassessing the situation as it unfolds. McDonald at that point is a suspect who has a knife, who potentially committed nonviolent crimes, breaking into trucks, stealing radios, popping a tire, scratching a window. Defendant Gaffney continued to keep dispatch up to date on what was taking place. They followed him for almost a quarter of a mile. They went past industrial buildings. They went past the intersection of Keeler and 40th Street. They went past the Greater Chicago Food Depository. They went past the intersection of 40th and Carlisle. And finally, they get through this parking lot at Pulaski. Officer McElligott would testify, Judge, that during this entire time, he never felt that McDonald threatened the use of deadly force. You'll also hear that there was testimony that Gaffney has testified that he did not feel at risk of death or serious bodily injury.
The objection noted, no rule.
Even though McDonald popped the tire and scratched the windshield of the car. As they neared Pulaski, squad cars began to arrive from other directions. So you've got lights flashing, sirens going. One car contained two officers, Viramontes and Dorfontaine. She can see Laquan McDonald as he's walking down Pulaski. But Officer McElligott and Defendant Gaffney have lost sight of him at that point. They hear shots. They arrive at the scene at 41st and Pulaski. Laquan McDonald is on the ground. When Officer Viramontes and Fontaine arrive, she sees Laquan McDonald turn and fall to the ground. She gets out of her car, comes around the front of the car as Officer Jason Van Dyke is shooting Laquan McDonald for the last of 16 times. She indicates and will indicate to the court that she saw this black male walk down the middle of the street and cross over the yellow line. She saw him swing a knife. She saw him turn and fall to the ground as her car approached, but she didn't know why he was turning. She didn't know why he was falling until after getting out of her car and realizing that he was being shot. She could hear drop the knife. She could hear the bullets. She saw him twitching. She saw the smoke come from his body. What she did not know and will testify to is that she did not see McDonald attack or attempt to attack anyone before or during the shooting. She did not see him swing the knife in an aggressive, exaggerated manner toward anyone. She did not see him continue to advance toward Van Dyke, nor did she see him raise his arm toward Van Dyke as if attacking Van Dyke. She did not see him raise knife across his chest over his shoulder. She did not see McDonald point the knife at Van Dyke. She did not see him attempt to get up while he was being shot by Van Dyke. She did not see him batter anyone. Yet the evidence will show that official police reports completed by defendant March and others contain those false statements. A video will show that McDonald walked southwest across the double yellow line across a full southbound lane on Pulaski. And the video will show that when they got out of the car, defendant Walsh did not back up, but instead advanced toward McDonald. Van Dyke did not backpedal and fire, but instead took 6 steps toward McDonald and fired his gun 16 times. But the official police reports contain those false accounts that defendant Walsh backed up and Van Dyke backpedaled and fired, as the evidence will show. The evidence will further show that there are laws, general orders, police policies, and procedures that govern police officer conduct. The laws and general orders require justification in order to use deadly force. Immediately after the shooting of Laquan McDonald, the issue of justification became important. Those who are sworn to tell the truth began to fashion a story, to shape a narrative, to provide false information, and create the lies that were designed to help Van Dyke avoid the consequences of his actions, to help Van Dyke avoid the punishment that might come with using deadly force without justification. Instead of protecting the scene, gathering names of witnesses, trying to find out who had a clear view of the incident, as required in general orders, the evidence will show that 2 citizens who were in their vehicle within yards of the shooting were shooed away by the officers who failed to ask them for any contact information, to give them contact information, or to even ask a single question about whether they saw what had happened. They gathered dash cam video and they viewed it at the Dunkin' Donuts, which was across the street. Officers Fontaine and Viramonte were put in charge of collecting preliminary information for the case incident report. Officer Fontaine will testify that that all of the substantive information that she put in her reports was given to her by defendant March. Defendant March told her to list the defendants, Walsh and Gaffney and Van Dyke, as victims of an aggravated assault by McDonald, stating that Van Dyke had been injured by offender. The evidence will show that witness officers at the scene that night were directed to the area headquarters to be interviewed by defendant March. But before their official interviews, they got together. Defendant Walsh and Van Dyke and detectives looked at video together and commented on what they saw or what they wanted it to show. Defendant March then interviewed officers who were on the scene and again did not take contemporaneous notes, did not confirm that his understanding of the statements was correct, did not show the officers notes so that he could check those for accuracy, did not offer to allow the officers to review the reports to make sure that the statements he claimed he got from them were accurate. The evidence will show that ultimately defendant March wrote police reports and included information that was false, including one statement that is false beyond any reasonable doubt. That statement was that the recovered in-car camera video from beats 845R and 813R was viewed and found to be consistent with the accounts of all witnesses. In fact, Judge, the evidence will show that the video from 813R directly contradicts the accounts of many witnesses as described by March. Defendant March's false statement is compounded by his complete failure to note where the video directly contradicts the statements given to him by witnesses, including defendant Walsh and Jason Van Dyke. The evidence will show, Judge, that defendants Gaffney and Walsh, as well as Van Dyke, also completed and filed within minutes of each other tactical response reports, you'll hear the term TRR, and officer battery reports, you'll hear the term OBR. And those reports contained identical information that they knew was false. For instance, that McDonald had not fled, that McDonald attempted to stab or cut 3 officers, that the 3 officers were battered, that the 3 officers were an imminent threat of battery, that McDonald had attacked the officers with a weapon, and more significantly, that McDonald had used force likely to cause death or great bodily harm with a weapon, all to justify Van Dyke's shooting and killing of McDonald. There will be testimony that when Officer Fontaine found out months later that Defendant March's reports included a false statement attributed to her, she was furious. She immediately contacted her lawyer. She wanted to set the record straight. But her reward for telling the truth was to be called a rat and to be told that she would not be safe on street duty. These simple, yet very important acts, lying on official police reports, are the crux of this case. Official misconduct, obstruction of justice, conspiracy to commit those acts. The evidence in this case will be clear. Defendants March, Walsh, and Gaffney each knowingly gave false information with the intent to obstruct the potential prosecution and punishment of fellow officer Van Dyke, and intentionally and knowingly provided false information in direct contravention to their duties and obligations under the law as public servants. And they conspired with others known and unknown to do so. Instead of serving and protecting all citizens of Chicago, the defendants tried to protect only one, Jason Van Dyke, by trying to create a false justification for the shooting of Laquan McDonald by Jason Van Dyke. Following presentation of the evidence, we will ask the court to find each defendant guilty beyond a reasonable doubt of the charges of conspiracy, obstruction of justice, and official misconduct. Thank you.
Thank you. Mr. McKay?
Thanks, Doug. Your Honor, David March is an innocent man. Not just because he's presumed innocent, it's because he actually is innocent. And what counsel just told you in her opening statement will not be borne out by the evidence. First of all, I don't know why she said it, but counsel interjected in her opening statement the race of Laquan McDonald. Race has nothing to do with this case. This case is about law and order. It's about Laquan McDonald not following any laws that night. There must be some individual responsibility attached to McDonald. Counsel says McDonald committed non-violent crimes. Nothing could be further from the truth. What she didn't tell you, but will be borne out by the evidence, Your Honor, is that night, while David March is at Area Central, because his tour of duty just started, Laquan McDonald is armed with a knife. Under Illinois law, Judge, you're going to find out that knife is a Category 2 dangerous weapon. And with that knife, he is committing forcible felonies. He is burglarizing trucks in a truck yard several blocks away from 41st and Pulaski, several blocks west near 40th and Keeler or 40th and Kedvale. There's a civilian she doesn't tell you about, Your Honor, whose name is Rudy Barillas. And when we want to talk about police reports, you're going to see the police report regarding Rudy Barillas, a victim in this case. Rudy Barillas is a truck driver. And that night, with his wife with him, he's parking his truck and he sees Laquan McDonald burglarizing trucks. Now, counsel will say that's a nonviolent crime.
Well, maybe, but it is a forcible felony, and that's important. It's important for David March and the complete investigation he did in this case. It was Rudy Barillas, Judge, who took his cell phone and he called 911. Do you know why Thomas Gaffney and Joe McGilligan are responding to the scene that night? Because an innocent civilian named Rudy Barillas called 911. And what happened next, Judge, is Rudy Barillas confronted McDonald.